Is Mr. Fortin there? Oh, there he is. I hadn't seen Monsieur Fortin. Wonderful.
To order, welcome to meeting number 97 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order adopted by the House on February 7, 2023, committee's meeting in public to begin its study or to continue its study of Bill C-332, an act to amend the Criminal Code controlling or coercive conduct. Today's meeting is taking place in a hybrid format. Members are attending in person, in the room, and remotely using the Zoom application. We have two witnesses in the first panel. Both are attending via video conference. Both witnesses have been tested for sound. Please wait until I recognize you by name before speaking. For the benefit of the witnesses, you'll be allowed a specific time frame for your opening remarks, as well as answering questions for each of the members. I will have to be a bit strict on the time usage, so please bear with me. I ask for your patience. There's a rotation that we follow. All comments are to be addressed through the chairs. And for members using the Zoom, you can either raise your hand using the Zoom function. And for those in the room, obviously, you know how to seek my attention. So I just want to welcome our witnesses for the first 45 minutes. We have them both with us by video conference. We have Barbara Schliefer, Commemorative Clinic, Deepa Matu, Executive Director, and from the Women's Legal Education and Action Fund, Roxana Parsa, Staff Lawyer. You each have 5 minutes for your opening remarks, and I will start with Madame Matu.
Good morning, Honorable Chair and members of the committee. I'm grateful for this opportunity to speak before you this morning regarding the proposed legislative amendments aimed at addressing coercive control within the criminal code. The Barbara Schleifer Commemorative Clinic since 1985 has been at the forefront of providing trauma-informed legal, counseling, and interpretation services. We support marginalized and racialized women and gender-diverse individuals who have experienced violence. With their extensive experience and expertise in this field, we offer insights into the potential implications of the proposed legislative change. I'll cover 3 points in my opening remarks. Justice should not only appear to be served, but it should genuinely be achieved, consequences of criminalization, and the need for a holistic approach to address coercive control. I want to start by recognizing and commending the intent behind this legislative change. It signifies a crucial milestone in acknowledging and addressing coercive control as a pervasive form of intimate partner violence. However, you must approach this legislative change with utmost caution, taking into account the intricate nuances and potential ramifications of criminalizing coercive control within the criminal code. Coercive control is characterized by a relentless pattern of behavior aimed at intimidating, manipulating, and inflicting harm upon survivors or the victims. This insidious form of abuse often operates behind closed doors, making it challenging to identify and prosecute. Survivors may endure multiple forms of tactics, including manipulation, financial control, and isolation, which can result in profound psychological and emotional trauma. My first point is that justice should not appear to be served. While the criminalization of the coercive control may seem like a solution, it's crucial to recognize its practical limitations and potential consequences. Coercive control, particularly within intimate partnerships, poses inherent complexities, making it difficult to recognize and report due to inherent power imbalance and the systemic biases that survivors face. Moreover, proving coercive control beyond a reasonable doubt in a court setting would add a layer of difficulty that survivors routinely face in IPV and sexual violence cases. In these cases, the system routinely fails survivors with underreported cases and low conviction rate. Therefore, my point being that justice should not only appear to be served with a new criminal offense on the books, but we should genuinely be trying to achieve this justice for survivors. The unintended consequences of criminalization don't always align with the intended solutions. For example, we have observed that existing mandatory charging policies in cases of domestic assault can inadvertently result in survivors being charged in the same offenses that were meant to protect them. Moreover, survivors, particularly those from marginalized and racialized communities, specifically from non-status immigrant communities, indigenous and LGBTQ plus communities face additional hurdles such as language barriers, discrimination within the system, and intergenerational trauma and lack of trust in the legal system. My last point is that it is essential to explore holistic approaches that prioritize survivor safety and well-being while holding perpetrators accountable within the criminal justice system. So drawing from the experiences and the jurisdictions where coercive control has already been criminalized, such as England, Wales, and Scotland, we must recognize the limitations of relying solely on the criminal justice system. It is only one part of the solution. Comprehensive support services, awareness campaigns, and professional training are essential for meaningful change and healing for survivors. Furthermore, the inclusion of a broad defense based on the coercive actor's best interests for the survivor raises serious ethical and practical concerns, risking further harm to survivors and perpetuating power imbalance within abusive relationships. In conclusion, I echo the sentiment of many others who have already testified in front of this committee that increasing criminalization is not the solution. An emphasis on the Nova Scotia's Mass Casualty Commission's recommendation, which advocates for a community-based approach over a carceral one, including a community advisory, is something that we also support. While we oppose the implementation of the new offense for coercive control, we stress the importance of equipping all legal actors with the necessary knowledge and skills to identify and address coercive control effectively. This includes developing risk assessment tools and training that consider intersecting identity factors for survivors that are disproportionately impacted by the gender-based violence. We believe that introducing such legislation prematurely without adequate education resources, accountability mechanism in place for legal actors.
Thank you very much. Thank you very much for your opening remarks, and you'll have a chance to continue with that during questions. I will now turn to Madame Parsa.
Good morning. My name is Roxana Parsa. I'm a staff lawyer at the Women's Legal Education and Action Fund, also known as LEAF. I'm grateful to appear today from what is now known as Toronto, which is on the traditional lands of the Mississaugas of the Credit, the Wendat, Anishinaabe, and the Haudenosaunee nations. LEAF is a national charitable organization that has worked for 39 years to advance the equality rights of women, girls, trans, and non-binary people through litigation, law reform, and public education. In recent years, LEAF's engagement with the criminal legal system has led to a deeper understanding of the ways in which harms can be perpetuated through the justice system. This is why we are grateful for the opportunity to be here today to share our views against Bill C-332. We know that coercive control is a pervasive form of violence. We have heard the stories from survivors and frontline workers about the insidious ways in which patterns of controlling behavior develop over time, and we understand the desire to respond. We agree that there is a need for greater recognition of this harm. However, we urge the government to resist reliance on the criminal law. We echo the calls of experts who have testified before you this past week in speaking against the implementation of this bill. There are significant systemic barriers that exist within the criminal legal system that will render this bill ineffective. First, coercive control is a highly nuanced and case-specific concept which captures a wide range of behaviors. The lack of physical evidence often means that recognizing the existence of this form of violence involves a deep understanding of the dynamics and context of an interpersonal relationship. Given the subtleties of coercive control, there's a significant risk that when granted judgment, law enforcement may misinterpret situations of abuse or see abuse even when it is not present. Abusers may also use this to their advantage and turn the law into a tool of coercive control, as we've seen with many other tools in the legal system. These risks are significantly heightened due to the existence of colonialism, institutional racism, and discrimination embedded within the justice system. There are decades of evidence which show how the criminal law harms survivors. We can look to the history of mandatory charging policies to see how the potential consequences of a new offense would emerge. These policies, while well-intentioned, led to a significant increase of arrests of female survivors, particularly amongst racialized populations. In Canada, this has been most strongly felt by Indigenous and Black women, who are at the same time groups that continue to face the highest rates of intimate partner violence. We fear the same consequences arising with the establishment of yet another criminal offense. We also know that despite facing higher rates of violence, the history of harm from the system results in a reticence to seek help. Many survivors will not contact the police when they are experiencing abuse. And when policing is seen as the primary solution to intimate partner violence, it inadvertently excludes survivors from marginalized communities and only deepens the existing inequities in seeking safety. In discussing the potential harms of criminalization, the conversation often claims that the benefits outweigh any potential risks. So we urge you to examine the question, outweighs the potential risks for whom? Who will be most impacted by a new criminal offense? The law does not exist in a vacuum, and when considering the development of a new offense, we need to center the experiences of survivors facing intersecting barriers to justice. Criminalization is likely to result in either a lack of protection or worse, cause further harm for survivors. And access to a legal mechanism is not necessarily access to justice. That is why, instead of focusing on the enactment of this bill, LEAF strongly recommends diverting resources to focus on prevention through the development of the infrastructure necessary for survivors to seek safety. This includes more funding for housing, social supports, and community services, and the development of alternative justice models for survivors seeking validation. We also echo the recommendation of earlier witnesses in advocating for mandatory and ongoing training to actors in the justice system on coercive control, as well as on systemic bias, alongside the development of accountability measures to ensure evaluation of whether training is meaningfully applied. Finally, we echo the Mass Casualty Commission's recommendations to strike an expert advisory group and consult with both experts and affected communities. Without systemic change, legislative reform only continues to hide the problem and gives the illusion of taking a stand. The criminal law has been turned to for decades as a response to intimate partner violence, yet the ongoing rates of violence show that it has been proven to be an ineffective response. We think it's time to look beyond the criminal system and focus our resources on developing the social systems that are necessary for violence prevention. Thank you for your time, and I'm happy to take any questions.
Well, thank you very much. Much appreciated. We will now start with our first round of 6 minutes each. Keep in mind, we need to conclude this panel in 30 minutes in order to have the second panel witnesses be tested as well. So I will start with Mr. Frank Caputo.
Thank you, Madam Chair. Thank you to our two witnesses for appearing with us. And Ms. Matu, I know you didn't get to finish your opening remarks, and I'm happy to yield my time to you to finish your remarks.
Thank you so much. I just had 2 lines left saying that we believe that introducing such legislation prematurely without adequate education, resources, and accountability mechanism in place for legal actors risk further undermining access to justice for survivors. And thank you so much for giving me this time, because I just was going to offer to answer any questions.
Okay, well, thank you very much for that. I appreciate you both being here. Ms. Matu, my full disclosure, my wife runs 2 legal clinics where she serves primarily women and mostly marginalized women. And my background is as a Crown prosecutor, so I listened with intent to both of you as to what you had to say. And I found it interesting. Very much interesting, and I'm just trying to decide where to start because there's so much. But I know that Ms. Parsa, when she was speaking about this, spoke about that a law on coercive control, and just generally, if I took your comments correctly, was that the law should not be the primary mechanism by which we deal with intimate partner violence and coercive control, and that there should be a rededication or a redirection of resources. My question is this. In these situations, the law is reactive. You're speaking about something proactive. But should we not be reacting to the situations of coercive control that, I mean, statistically and in my experience, lead to and perpetuate what I would call and what others have called the cycle of violence? Just feel free to answer that.
So I can take the question, and Roxana, please add. I mean, if Canada recognizes coercive control as a criminal criminal code or a criminal, I know what I'm trying to say here, but I'm getting nervous. I don't know why. I usually never get nervous. Another section on the books. My challenge is like looking at things